Thanks very much. Am I audible? Okay, great. Thanks very much for having me. I'm delighted to be here, and thanks to Ollie and to Wen for hosting. It's great to be able to come out and talk a little bit about some of the work we're doing in the libraries around AI. I'm Scott. I'm the head of serials and electronic resources. I work down in the Madison building, down in the technical services building down in the Madison office. So I don't work in Schroeder. And I'm delighted to be able to get out and talk to faculty and students in programs. The work I do with electronic resources involves negotiating and acquiring those resources that the library provides for the whole FSU community. So we're going to talk a lot about copyright as it relates to the license agreements for the content for the libraries. So AI, of course, is everywhere and in everything, but the two aspects I'm going to talk about are the use of AI with the content that we license in the libraries, what you can and can't do. And then there's the other side of it, sort of the output idea. When we research and publish things, having used AI with the library's content, what does copyright look like around that part of things? So cutting into two pieces, the input, how we use our library content with AI, know what we're doing with the output of it. Casey, nod off. These are the three things I hope you take away from this presentation. All of the usage that you do with our library resources is governed by license agreements. We have about 300 active license agreements, and they're all individual, and we have to negotiate them individually, and they all have different terms, which you can and can't do. So the AI tool that you use with our library resources matters. We'll talk more about that in a second. And if you are putting your research somehow, having used AI, make sure you read the publisher license agreements that govern the use of what you're putting out. Talk a lot more about that in a bit, but hopefully this is what I can cover and what you'll take away from all of this. But first, a little story. Last September, FSU researchers over at the Mag Lab did a lot of work that ended up being published in an article online. What they did is they looked at the FSU library's databases. They downloaded about 600 articles and they put them in an LLM and did some research. And this was all published. My question is, it caught our attention in the libraries, of course, for lots of reasons. It's great that they're using our resources. It's a benefit to them. But was this suitable use of our resources? Did it pose risk to the university by ingesting our content into an LLM? It's a very important question. Did it violate our license agreements? Or specific? Anybody have an opinion on that? Does anybody know that it could be a risk to our licenses in the university?
I guess what's the violation?
I'll go ahead and give you the answer. As any good lawyer would say, it depends. Right. So we'll move on that a little bit after we've gone through some more stuff here. I'll try to hurry. So to tell you a little bit about the libraries, we license a ton of content for the FSU community. This is a screenshot from our library management system about the different kinds of content we license over here. But the most important thing is, over 126,000 journals that come out with articles every year. We have millions of articles. We have about 3.5 million ebooks. All of this content that the library provides is governed by license agreements like this one. This one from Taylor. You don't have to read the whole thing, but the idea is that vendors have intellectual property rights of this content that they are providing us and that we are using. So let me take a second to say, when I say vendors, I may say publishers, I may say content providers. For these purposes, it's all the same thing. I'm talking about Elsevier, Springer, if you use any of those journals. I'm talking about Reactis, ACS journals, any of this content that you access through the library. We buy this and make it available. But all of that, your usage of that is governed by these license agreements where the vendors are trying to protect their copyright interests and their intellectual property. So what you can and can't do about what's in the license agreements. As we negotiate these license agreements, again, individually with vendors, we have a lot of library concerns that we're moving through, including things like, can we ILL them? Can a professor put them on course reserves? Can we share them with people outside our university? I guess you haven't thought about these things. I know this is kind of in the weeds, but there's a lot to the license agreements that we negotiate with vendors. On the business side of things, this is FSU writ large, right? There are lots of business terms that the university helps us with, things like indemnification and governing law and venue. We will not promise to litigate anything with our vendors in Wales, for example. We need Florida law. I think lots of different concerns that we've been doing this for decades now as electronic resources and content come around, kind of used to it. Publishers are used to it and their legal departments are pretty used to it. And then along comes in November 2022, public access to artificial intelligence, generative AI. What do we do with this? I think it's fair to say that it caught publishers and more importantly, their legal counsel by surprise just as much as it did the rest of us. They were very unaware of what that means to their intellectual property and how it's going to be used. So very early on in 2023, the legal departments of these big publishers said, you cannot use any of our content in any way with any artificial intelligence tool, right? It's proprietary content. They have legitimate concerns we'll talk about in a second, but it was very prohibitive. In January of 2023, maybe that wasn't such a big concern for us. We didn't realize what the impact was going to be just yet. Here are a couple of other license agreements that essentially say you cannot use our stuff with AI. Well, as time went by, that became kind of silly, right? AI is everywhere. It's available to everyone at any time. You can't possibly, in the libraries who are processing these license agreements, vouch for the wide array of usage for the entire FSC community. Essentially, what vendors were asking us to promise as we sign these license agreements with that language in it is that not a single user anywhere will put an article into ChatGPT and ask it to do something. We can't promise that. That's silly, right? It becomes even more silly with the proliferation of AI over the next 4 years and just the availability of enterprise level tools. You can hardly open a browser without interacting with AI somehow. So we just can't promise that. So we're still negotiating AI in our license agreement, even though it's been out for 4 years now. It's still kind of early days in terms of negotiating how we use vendors' content in the library. Vendors have very real concerns. And what they're trying to do is protect their own intellectual property. Mostly, they don't want their intellectual property being accessed by users who then take it and build an LLM and then sell that, because then they've lost their ownership rights, essentially. It's not too unusual. It's something vendors have been concerned with for a very long time, but AI makes it a lot different. They're also concerned with creating a commercial product with your research that was built on their data. Their intellectually owned property. So they have some other concerns about sharing outside the university and attribution of their resources. But in the libraries, we're arguing the same things we have always argued in the use of content. We want to use your content for research and educational purposes, right? That's why we've always done it. We want to argue for fair use, right? This is a fair use. Being able to use a tool to interrogate the data that you have is simply fair use. So we're negotiating that skirmish line vendor by vendor as we go. As recently as just last fall, vendors were still asking us to promise not to use their content with any AI tool. You can't. So it's an ongoing battle here. Fortunately, last year, or maybe a little bit before, FSU jumped in with AI presence and gave us a lot of backing. Our procurement department has learned a lot more about AI. We also have in our negotiation struggles with vendors, support from the international library community. This is the International Coalition of Library Consortia, very very powerful, very loud voice for libraries, arguing that AI is fair use. And we need the ability to use AI tools with the content that we license in the libraries. ARL, Associated Research Libraries, also had a statement regarding it. So we have a voice in arguing this. This is one of the loudest voices in arguing for fair use rights for artificial intelligence. The Office of Scholarly Communication at the University of California, they've responded to legislation. They've argued very loudly that we need fair use rights for AI. It is by no means settled law. So these arguments are important. These allies are important in arguing all of them. So we push back in our vendor license agreements. This is us just saying, no, we're not going to do that. We have to have these rights. So where we've landed, seemingly, over the last year or so, is with this idea of the closed hosted environment. This is a license agreement from Elsevier, you might know them, saying, okay, you can use AI tools, but they have to be in a closed hosted environment. That is, your use of our content with AI can't go beyond the scope of your institution, right? You can't use it to train an outside LLM. You can't export it to other users, protecting your intellectual property again. So this is another one from IEEE. You might know it saying the closed hosted environment. That's becoming more and more common in our license agreements. We're fortunate at FSU to have closed hosted environments. We have a contract at the enterprise level, Microsoft Copilot, and a Google license to use Gemini and Notebook LM. As long as you use these tools, having logged in with your FSU ID, and that's critical. We have some faculty who go home and log in with their personal ID. That's not being shared and saved in FSU's local environment. You need to log in with your FSU ID. That puts you in FSU's instance. All the work you do there is going to be contained within FSU borders, so to speak. And it won't be exported and it won't be used to train according to our contracts with Microsoft. They're AI products. So that's a good thing. And that's the closed hosted environment that vendors are talking about using. What schools who don't have these environments do. I don't know what, for example, smaller colleges do. We have new licenses coming out all the time, new negotiations all the time. This is one recently with Taylor and Francis. The interesting thing about this is our early license agreements around AI showed up in the sciences, ACS, IOP, Institute of Physics, IEEE, a smaller subset of our wide university mission. Our bigger vendors who provide a wider swath of subject area content are now adding AI language. Taylor and Francis, 1,500 titles that are largely social science and humanities titles. Springer Nature is another one. They have 2,200 titles, a wide swath of subject area interest. So this is becoming more important to the whole FSU community. And some of the language that they put in their agreements, it's interesting. This is just to illustrate that they're all very different and they all have very different concerns about how their intellectual property is used. This is an interesting statement down here at the bottom. Usage of the content with third-party AI is not the subject of this license agreement. It's your responsibility to regarding intellectual property. So there are lots of chemistry resources with AI language in the license agreements. And when I say there's AI language in there, it means essentially that you need to use those resources in a closed hosted environment. Things like ACS and Reaxis and Science Direct from Elsevier, Springer Materials. If you use any of these things in your research, you need to use that environment. So one of the top ACS publications, the American Chemical Society, I have an asterisk on. Some of you may have seen this on the ACS pages somewhere. They basically already published if you work for a Florida public university, you can publish free open access. This is open access. It's a little bit of a different topic than AI and copyright. But the point here is we have not yet completed this license agreement. So we have not advertised anything about this yet. This is a statewide agreement for all the public universities in Florida. There's a single agreement that goes through a consortium with that to get. When that's available, there'll be more about that. An interesting fact, yes, the license agreement access started in January 1st of 2026, but the agreement is not yet. How can that be? Very good question. Ask me after that. So we're trying to get the word out about use of AI with our library licensed content on our library web pages. If you do a search in our catalog and you find an article down here at the bottom where you see the access link, you'll see show terms of use. And what we can do within the limitations of our library software is share with you whether this can be used with, for example, AI, whether you can do text and data mining, and all the other license rights that are included. It's a little bit clunky, it's a little bit onerous to look through, but it is there if you want to look it up. Again, we're at the limits of our library management system. On our databases A to Z page, hopefully that's familiar to you, where you can look up individual databases and access them that way. We've put a guide describing responsible use that has lots of other information about how to use our library content. Don't, for example, look up an art store image, print it on a t-shirt and go sell it in the union. Hopefully that's an obvious violation of our license agreement. But along with all that other stuff, there is a section on artificial intelligence that will recommend to you, again, use Copilot, Gemini, Notebook LM in our FSU closed hosted environment. So that's the issue there. So I said it's going to talk about two aspects of AI. That's the incoming, what we can do with the intellectual property and the stuff that we license. And now I'll talk a little bit about the output. When you publish something, having used AI with our library content, what are your rights? What do you? I'm a little bit less versed in this than my colleagues in the library. This is from the Office of Digital Scholarship and Research. If you have questions about publishing your work, please reach out to our Office of Digital Scholarship and Research. They're happy to help. They have lots of data here. This is precise. They help me say some of the things I'm about to say here. So far, our license agreements with AI language in them have been on the front end, how to use their content. There's very little about what happens when you publish having used this content so far. More language is coming. We're starting to see it just this year in license agreement. Taylor and Francis is one of them. So when we publish whatever it is that you published, having used AI with Taylor and Francis content, it is subject to these terms. They're very restrictive about external display and distribution of their content. It cannot be made open source or used to train third-party models. That is, your publication cannot be used. Not just take content. It's your publication having used their content, training third-party models they're against. At the end of the contract, you would cease all use of AI and your research with that content. So there is a lot of language about it. Spring of Nature is another interesting one of our new contracts. You're sharing, even sharing your own data that you used Springer material to inform must be to limited amounts necessary for legitimate research purposes, right? There are limits on what you can share to our licensing. They are very explicit about not using your content, your published content, to train third-party models, right? Again, protecting their own intellectual property, their own content. Okay, so this is an interesting new agreement we have coming. I don't have the publisher here because the agreement is done yet, but we're looking at it, requiring appropriate attribution. This was curious. I put it in here just for fun. It says essentially that you will abide by your own institution's policy about sharing data that you've created with AI. Seems kind of silly. Why would we promise to abide by our own institution's rules in a public content? Just to illustrate that language is very weird. It's very unique to each vendor, and it depends on what their ideas of protecting their intellectual property. The question we get a lot is, how do I know that whatever I publish won't be ingested in an LLM or an AI product? Sorry to say you don't, and we're not going to know that. It's very difficult to know. These two examples, Taylor and Francis in 2024 sold their entire corpus to Microsoft to train Microsoft's product, right? So if you publish something with Taylor and Francis, it is now in their AI, and you have, well, you've surrendered some of your ownership over that content. Wiley is doing the same thing. Wiley is selling a lot to companies making medical AI models. They have a lot of money doing this, and this looks like the new model for publishers in recovering revenue that might be lost to open access publications, selling their corpus to AI companies that are building models, and there are loads of them. Taylor and Francis made $10 million off that deal with Microsoft. Informa is their parent company, is estimated to have made $75 million so far selling their stuff. That is stuff that they have gathered from researchers like you publishing in their journals, right? Wiley is you guys still have made $110 million already in their life, so it's big money. This is constantly being litigated, so this is not at all settled. How much AI can just grab and ingest stuff into their system, right? The Copyright Alliance estimated there are 86 cases ongoing right now against AI companies for having pirated or ingested materials that they don't have intellectual property ownership over. There's another website called ChatGPT is Eating the World. You can probably guess where they stand on all of this. They're tracking 131 cases. Unusual platform, but it does look to be legitimate as far as the cases track is. Point is, it's still being litigated, and we are still learning about this new frontier of publishing and the use of AI in the work. This is probably the biggest one. If you're not familiar with this, this was last year, the big case, Mars versus Anthropic. This had to do with books, but this is a big deal in the publishing world. The judge ruled that ingesting books into Anthropic was a transformative use of the content and thus protected by fair use. It kind of split the baby, so to speak. It also decided that they had illegally obtained that content, and Anthropic paid a big fine to the users who owned the intellectual property that. But they got to keep the scans, and they won on fair use. So for them, it was easier to ask forgiveness after having done it than to ask for permission on the front end. And it was cheaper. They wrote a check, and it was far more expedient. That is to say, it was way faster. Let's just do it. We built the thing. And by do it, I mean, let's harvest all of this data that might be your publication illegally and use it to build our. Before that continues. This is just the Authors Alliance affirming that using work as training materials for AI is expressive fair use, and there's no way around that now. So what do you do when you're ready to publish your research having used AI? These are considered best practices now. This may change in a year or in 6 months. Now, no AI as an author or a co-author. Straightforward. You need to disclose substantive use of AI. Basic tools like an editor or what we used to think of as grammar checking are okay. You don't need to disclose those. And most importantly, don't use your paper, your output, to train a third-party LLM. And when it comes to the publisher agreement, when you're ready to engage with a publisher to have your content made available, make sure you look at the license agreement that they provide. That's not something that we do in the libraries. That's done individually. But our department, our Office of Digital Scholarship and Research can help you with. but read and negotiate what the terms are. Find out whether that company is selling everything to AI. Okay, Francis, I would be worried. Wiley, I would be worried that your content has gone and sold to AI. If you want to maintain your rights not to have your content, your paper used to be an AI tool, then you need to be very specific about the license. There are also digital research and scholarship. They have publishing workshops. They are just about to announce 2 new ones. They're not ready yet this session, but on October 6th and November 10th, if you're interested, managing your publisher rights and you're out there. They'll have 2 great workshops on that. Keep an eye on this space, our library space, or ask me for more details. So our team also recommended a few things. If you are publishing, this is the Spark site. I'm getting low on time, so I'll run these quickly. They have great advice about author rights in their addendum. This is the Copyright Alliance. There's a ton of work on the Copyright Alliance about publishing and sharing your material. Interesting guide from Adelphi University about knowing your rights when you're publishing and use. There's another site, Outre, seems to be more about medical publishing, but has some great information. And lastly, this is probably the most important one, the Generative AI License Agreement Track hosted by IFIC SNR. If you're wondering whether your publisher has sold content to a third-party AI, it's in here. It's this license tracker. Okay, so back to our story now. About a year ago, 2 FSU researchers used library content, downloaded about 600 articles, and built an LLM and ingested in that LLM. What are the things they should consider? Whether this was authorized use or whether this may have introduced risk to the library. So a couple of things. Assuming they were authorized users and they accessed the content correctly, when they pulled it down, they didn't use Copilot, they didn't use Google LLM or our enterprise level closed hosted environment. Tell me more about the LLM. By the way, if you worked on this, I'd love to talk to you. Tell me more about the LLM. Is it public or is it in our closed environment? I don't know, so it depends is the real answer to this question. And what did they do with what they published out of this? Did they make it available? Did they train a third-party LLM with their research? Hopefully not. How widely did they share it? Again, all those other rules we talked about. We don't limit. Something the libraries might like, whether this did violate our license agreement, but be wary. There are conditions under which you can use our library. Okay, so again, license agreements cover how you can use our content, the AI tool that you use with our content matters, and make sure you know what you can do with your published output and you negotiate your agreements with publishers when you're having your work. That's it.